again, I don't think that the Supreme Court intended on giving any president, let alone Donald Trump, the ability to escape liability wholesale. Because if that were the case, they would have written him a blank check back then. I also think.
Well, the cynic in me would say, this was just the Supreme Court's ruling on immunity was the precursor to the blank check, and it bought Trump time, and it laid out how the Roberts Court interpreted it, which was they didn't really want Trump to be prosecuted at all. They thought the indictment was too broad. That's just my cynical kind of personal view. We don't, this is not reporting based. This is just our interpretation. And I don't know. I feel like the more I look at the ruling and think about how it might be applied, I can increasingly envision a way for the court to decide. For instance, you raise this thing about Trump deciding pre-election that he was going to call the results false and fraudulent and not accept it and just declare winning anyway. Yeah. But let's say, but I take that point. Why couldn't the Trump lawyers then say, fine, leave that in, you can take that to trial, but you can't take all of the conversations afterwards about him talking to his vice president, him talking to Bill Barr, him talking to other White House officials or people adjacent to him saying that he had lost the election? Because isn't it in the president's prerogative to talk to whoever he likes, and if he thinks someone's advice is wrong, he doesn't have to follow it. That's what presidents do. They listen to other people.
But the ruling, Hugo, allowed for those conversations with the DOJ to be excluded, right? But when you look at what Jack Smith did, and you look at the Bill Barr section of the Jack Smith motion, he says Bill Barr went on national television and other media outlets and said that there was no election fraud. And he did it without consultation with Donald Trump. So remember, the immunity runs to the president only. The immunity doesn't run to people outside of the presidency, right? And so Bill Barr, independent of Donald Trump, made a declaration that there was no election fraud. So why would what Bill Barr said from an evidentiary standpoint be excluded? Why? And why wouldn't a juror be able to rely upon that as a basis to determine whether or not Donald Trump knew or should have known at that time, right, that there was no election fraud?
Public statements, I grant you that. I'm in agreement with something like that.
Okay.
I'm just trying to, and in this exercise that we do, you and I, it's like I'm always trying to have a sense of where Trump world might go to have a sense of how this might play out. And while I feel like something like that is untouchable, I can see the Trump lawyers trying to make a big meal out of, say, someone like Eric Hirschman. This came up in the recent Jack Smith filing. Eric Hirschman, they go into a long discussion in the filing about how he was a longtime friend of Jared, how he had this hybrid role of one of the White House counsels, but also an informal advisor who was a conduit to the campaign and played this sort of hybrid role. And Eric Hirschman was telling Trump, obviously, and Trump world that Trump had lost. But to me, I can see the Trump lawyers making an argument that someone like Eric Hirschman, whose testimony the special counsel's office relies on in a big way as well, by the way, as did the January 6th committee, but he would fall into the category of like an informal White House advisor. And if you start prosecuting Trump or former presidents based on their conversations with informal advisors, that might have a chilling effect on the executive branch.
In what capacity? Because if the guy's a, quote, informal White House advisor, he's not a part of the government, right? He's not a part of the executive branch. He's not a part of the DOJ. He's not a part of even any department or any type of, he's not a part of anything of the administration, right? So why is there immunity for that?
Because you're chilling, the Trump lawyers say because you're chilling the president to seek counsel from anyone and to do that confidentially to make up his mind. For instance, if it was the Bush White House and Bush was relying on an informal advisor to say, what should we do about, the CIA's torture program, and any decisions I make based on our discussions, I want that to remain confidential so that I'm not chilled in the future from having these informal, candid conversations. That has been the basic understanding of executive privilege for a very long time, and that has also been the understanding or the reasoning that goes into speech or debate clause that protects members of Congress's communications as well. And I think there is room for the Trump lawyers to make that sort of argument, I think ultimately would be unsuccessful. But I also see that potentially carving out chunks of the superseding indictment.
Well, I think the problem would be, though, again, that the Supreme Court could have, like it did in the original immunity ruling, say that the absolute criminal immunity bucket includes informal advisors to the President of the United States. What would have stopped them from doing it months ago in July when they issued that immunity ruling? They made sure that they included explicitly in that ruling that the immunity extends to conversations with people that are in the DOJ, for example, right? I mean, they made sure that they included certain people. So why not include any and all informal advisors to the executive office of the President of the United States? They didn't do that. I actually think Trump's stronger argument is one that they've already raised, which is the allowing of testimony to the grand jury concerning things like Mike Pence and communications with Mike Pence, et cetera, quote, taints the entirety of the indictment. And that is the reason why the indictment should be dismissed, right? So
But
let's
that's an
not,
easy fix.